Good morning, everyone, and welcome. My name is Gary White. I'm an Assistant Attorney General, and I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in today's proceedings. Today is Wednesday, February 21st, 2024. The time is 9 a.m. This is the time and place for the hearing examiner proceeding for docket number 2024-008 and cause number 132-27. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interest, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton formations comprised of sections 31 and 32, Township 2, South, Range 3 West, USM, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before we begin, are there any members of the public or respondents present that wish to comment in these proceedings? Okay, hearing none, let the record show that there's no public or respondents present for comment. I'll take appearances of counsel at this time.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear PLLC on behalf of petitioners XCL Asset Co. and XCL Resources.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Before we begin in earnest, just some housekeeping items. I have received declarations from a Mr. Kevin Anonson. Did I say it right?
Anonson, I think it's
Anonson. Okay, I want to say it the way he does. All right. I've received declarations from Mr. Kevin Anonson and Mr. Mark Gravy in this matter and have reviewed them before the hearing. Does the division have any objections to these declarations or the declarants being qualified as expert witnesses today?
No objection by the division.
Very well. Let the record reflect that they will be recognized as experts in their particular fields of expertise for this matter. And Mr. Mayo, are those witnesses present today?
They are present remotely.
Excellent. And that was pursuant to board order?
That's correct. Entered, I believe, re-entered yesterday because I made a mistake in the pleading that you ran.
Very good. Can we have the two witnesses sworn?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Mayo, go ahead and proceed with your presentation.
I'm happy to. This may be a little clunky because you actually did a great job of doing some of the introduction that I was hoping to do, so if you'll indulge. Again, Mitch Mayo, Lear & Lear on behalf of the petitioners in this matter, XCL Resources and XCL Asset Co. With me today, as you mentioned, are Kevin Anonson, who is the Vice President of Business Development and Land for XCL, and Mark Gravy, who's the Executive Vice President for Reservoir. If you'll raise your hand, Mark, just so everyone on YouTube can see who you are. Thank you. As mentioned, Mr. Gravy and Mr. Anonson are recognized as experts in their respective fields for purposes of this cause, and each of them have submitted their full testimony to be considered here today in the form of a declaration. Those were submitted last week, February 15th. This matter was referred on January 17th by board order to this hearing examiner proceeding on the stipulation that this matter remain uncontested. At the outset, I'd like to confirm to everyone here that this matter does remain uncontested and is proper in this proceeding. The board, and by designation, the hearing examiner has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5 and the implementing regulations. A copy of the REA was sent by certified mail to the known parties to be pooled and by regular mail to all other production interest owners within the drilling unit. In addition, a copy was sent to BLM, CITLA, and all the federal and state tribal agencies due to mineral ownership within the drilling unit, including the Division of Forestry, Fire, and State Lands. In addition, notice of the filing of the REA was duly published in the papers as required under the regulation. On February 7th, the division filed a notice of non-opposition in this matter, pending the presentation of evidence in the declarations in here today. No other objections or responses to the REA were timely filed. As brief summary, to the extent that the folks would like it here today, this cause involves compulsory pooling of a drilling unit established in cause number 139-153 and covering the entirety of sections 31 and 32 in Township 2 South, 3 West. In accordance with that order, as modified by Order 130-21, XCL drilled the 8 Maximus wells that are at issue here. There are, at this point, 3 named parties to be compulsory pooled. In the request, there were 5. 2 of those parties have leased during the pendency of this action. The 3 parties to be pooled here today are Urban Fund D-1 LP, Urban Fund IV LP, and Mark Massey. As reflected in Exhibit M, declarations filed on February 15th, the aggregate gross working interest of the parties to be pooled is about 1/3%, 0.3378. As outlined in Exhibit I and paragraphs 18 and 19 of Mr. Annenson's declaration, notices of opportunity to participate were provided to the parties to be pooled, but none timely responded. In addition, as addressed in paragraphs 16 and 17 of Mr. Annenson's declaration, there are several estates to be pooled here today. XCL believes it has leased all of the heirs of these estates, but out of an abundance of caution due to a lack of sufficient probate on these estates, the estates are included to be pooled here today. Pursuant to board order on January 17th, again, XCL published the requisite notice of opportunity to participate to the estates and anyone claiming by, through, or under them. Exhibit K on file in this cause shows the affidavit of that publication. As reflected on Exhibit H and discussed in paragraph 31 and 32 of Mr. Annenson's declaration, the average weighted royalty to be applied here today is 18.766255%. Finally, as the record reflects, none of the parties identified in the REA as being pooled and still to be declared as non-consenting owners in this cause, timely filed a response or have made an appearance today. With that, I'll begin with a quick testimony by witnesses. Mr. Annenson, could you please state your name and business address for the record? And
Kevin Annenson with XCL Resources. Our address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007. And I am the Vice President of Business Development and Land.
okay, and as the Vice President of Business Development and Land, do you have responsibility over the drilling unit at issue today?
I do. That's correct.
Okay. Briefly, I'd just like to ask you a couple questions about the declaration testimony that was submitted last week as Exhibit M. Are you familiar with that exhibit, specifically the declaration of Kevin Annenson?
Yes.
Have you reviewed that in its entirety?
Yes.
Did you sign that declaration or authorize counsel to sign it on your behalf?
Yes.
And is that your full and accurate testimony here today?
That's correct. Yes.
Okay. Finally, is there anything you'd like to add or clarify to that testimony?
Not that I can think of now.
Okay. And in your expert opinion, are the terms and conditions of the JOA that we've submitted as Exhibit G fair, reasonable, and consistent with those commonly accepted by the industry and in the basin?
Yes.
Okay. One point of clarification, Mr. Annenson, before I let you go. The division asked a question offline beforehand that I think it'd be good to get on the record. The JOA that you submit contains, as an Exhibit G, contains a 400% risk compensation award in it. But is it correct that XCL is requesting a 300% non-consent be applied in this order?
That is correct.
Okay. With that clarification, there's no more questions for Mr. Annenson. If you'd like, I can ask Mr. Gravy questions, and the division hearings ender can ask questions of both witnesses simultaneously.
That's great.
Thanks, Mr. Annenson. Hang tight. You may be asked a couple questions in a minute.
Okay. Sounds great. I'll mute.
Mr. Gravy, can you please state your name and business address for the record as well?
Mark Gravy, at XCL Resources. Our office is 600 North Shepherd Drive, Suite 390. My title is EVP Reservoir and Development.
Okay, and as the EVP of Reservoir Development, do you have responsibilities for the drilling unit here at issue today?
I do.
And I'm just gonna ask you a couple of questions similar to I asked Mr. Amundson. Essentially, the exhibit M that was filed last week, the declarations testimonial, specifically your declaration of Mark Gravy. Are you familiar with that exhibit?
I am.
And did you sign that exhibit or authorize your counsel to sign it on your behalf?
Yes.
Are you familiar, have you read and are you familiar with all the allegations contained in the affidavit, the declaration?
Yes.
And does the declaration constitute your full and accurate testimony at this hearing here today?
Yes.
Are there any clarifications or corrections you'd like to make on the record?
None currently.
Okay. Couple last questions for you. In your expert opinion, were the actual costs of the Maximus wells as drilled, as reflected in Exhibit J, are they fair, reasonable, and necessarily incurred in this development?
Yes.
And in your expert opinion, was each Maximus well economic, as that term is defined in the 139-153 order when they were drilled?
Yes, we believe each of the 8 wells to be economic.
Okay. Last question. In your expert opinion, do the risks discussed in paragraphs 14 and 15 of your Exhibit M, your declaration, justify the imposition of a 300% risk assessment award in this cause?
Yes.
Okay. With that, I have no further question for the witnesses, and I'd open to the division and board for that, or division and hearings examiner, excuse me.
Mr. Haynes, questions for the witnesses?
Yeah, I just have a couple of questions. They're probably more just clarifications on our part. This is to Mr. Amundson. Your testimony indicates you sent out election letters to ConocoPhillips in November of 2022, but that interest has since been, well, they didn't respond, and that interest has since been assigned away. Could I just understand, was that assigned after the 30 days, just to get a clarification there?
That is correct. They actually sent to us an email from their landman at ConocoPhillips that they were going to non-consent those wells. And so we actually have non-consent. And then after we received those non-consents, they assigned those interests later to a group that we had never heard of. So they're not a subsidiary or anything of, I don't think they are, just another group.
Okay, and Urban, because that was after you'd already noticed Conoco, they weren't given a participation letter.
They have not, because Conoco actually non-consented those wells, so they would be subject to that non-consent.
Sure.
And it was beyond the 30 days as well, so kind of
Right.
double whammy there.
Have you, Urban, but I assume we have an active address for them and they were notified of this request?
Yes, that's correct. We did send them the address on the assignment we sent over to Urban of the RAA. That's correct. And we never heard anything back.
All right, thank you. I also have a question about the 2 parties that are no longer part of the non-consenting poultry pool parties.
Yep.
Marie Ludlow and Paul Wallace Winiger. Have they actually leased?
They have, that is correct.
Okay, great.
I got a question.
Okay.
So of the 8 wells, and this may be a combination of Mr. Amundson and Mr. Gravy, but do you know, I know these were batch drilled wells. Do you know kind of the time frame between the spud of the first well and the 8th well? And then on top of that, were there any leases? I'm assuming not, but any leases taken between the spud of the first well and the last well? So would there be any change to the average weighted royalty between any of those wells is kind of the question I have.
I could look at the dates. I can pull the dates here for you on those. But to answer your second question, or Mitch may have those exact dates, or maybe somewhere in the order, but the only leases that were taken was the Michelle Ludlow and the Paul Wallace Weinger. And we actually did not include that as part of that because they leased after the first spud. But it's such a small, the interest is, or it's 0.00003119. So if we were to do that on a 1280, it was 0.03 acres. So probably wouldn't have much of a change of the average weighted royalty as it is, but to answer your question, we did do it. We did do the average weighted royalty, not including those since it was taken after the spud.
And Mark, just to help clarify, if you don't know the exact spud dates of the wells, can you talk generally about how quickly you guys are moving from spudding one well to the next when you're doing batch drilling? Just kind of help explain this development process on the Maximus, for example.
Yeah, I don't have the exact dates. I'm happy to look them up. But approximately the way we develop these wells is we set conductors, which takes a couple days per well, or about a day per well. And then we set surface casing, which takes about 3 days per well. So building the pad, setting conductor, setting surface casing is roughly a 3-month process. And then to drill 8 wells is roughly 160-ish day process, maybe a little less than that. So about 5 months. And then there's usually a lag because you also need to drill the offset unit before you can complete the wells to prevent any interactions occurring between the completion equipment and the drilling rig, because the drilling rig utilizes oil-based mud and the completion equipment is pumping water. So you need to be finished drilling the offset unit as well before you can begin completions of any of the wells. And then once both units are completely drilled, it takes about 5 days per well to complete. I don't have the exact dates, but it's roughly a year from project start to initial production.
So when you're setting conductors though, you're doing one and then immediately moving to the next one, immediately moving to the next one, just like that.
Yes, in general, that is how we do it because the conductors need to be set before the drilling rig arrives. And then we bring a smaller drilling rig in to set the surface casing usually because they're experts at it and because the cost exposure is less to use a smaller, more appropriately fit drilling rig for that activity. So you bring in a very small unit to set your conductor, it leaves. Usually you bring in a small drilling rig to drill the surface casing. And then when it leaves, you bring in the full-size drilling equipment.
So in this case, you're talking, well, drilling probably a few days to a couple weeks if you're counting the surface casing between first one start drilling to the last one start drilling.
And I think I know where you're headed, and that's kind of the whether you start with the first Maximus well or the 8th, or you start at the 8th, you start at the,
We're talking
it's
days.
arbitrary. And so picking what we've kind of decided as a kind of philosophical position is just whatever the first bud of the batch of wells is the date to use for triggering that acreage weighted. But if the board or division would like individual acreage weighted royalties for each well, assuming there's a lease taken in those couple of days, we're happy to do that.
And I do think the definition on reporting wise to the state is at spud of conductor. That is when the well has initiated drilling as far as reporting definitions.
That would be my take on it as well.
That's the dry
So we're
spud
talking-
or whatever on the
It's
division
a few
side.
days.
Okay, we'll have to talk after and make sure.
Yeah, and we did, like I said, we did omit those from the calculation, those 2.03
Weren't
net acre leases, so.
those were after the fact?
Yeah, they're asking Kevin, it's
Right.
basically the day the first Maximus well spud, between then and Maximus well spud. If there are any
Yeah.
leases.
Yeah, and we agree, there was those 2 leases that were taken. And like I said, we did omit that from the average weighted royalty since they were taken after.
Oh,
And then, yeah, I think that was the question. And like I said, And then I just got a note, says the Jenny 79, or the Jenny started July of 2022, and then Maximus in September 15th of 2022. That was the 2560s, yeah.
Any further?
We can get the exact dates if we need them.
Thank you.
That's over.
Any more questions from the division?
We have no further questions.
Mr. Anderson, I just have one question, I believe, for you. If you go to your declaration at paragraph 16 and 17, at paragraph 16, you discuss the deceased parties and you list them. And then at paragraph 17, your declaration states, although XCL believes it has identified and leased all individuals and or entities entitled to an interest under the estates, in the absence of a court order conclusively determining succession of ownership, XCL must pool the estates out of an abundance of caution. Can you just help me understand that first part of paragraph 17 of the declaration, why it is that XCL believes it has identified and leased all individuals or entities?
Yes, yeah, in most cases, the interests are usually so small that most folks don't spend the the money to go get these properly probated and whatnot. And so we take the business risk, or we go off of whether it's affidavits or it is some type of document that makes us conclusively take that business risk. And so we believe that we have leased all the correct individuals based off what we have in our files and what we've researched. And so, but just in case we may have leased the wrong person, which in this case I don't believe we did, we still send these out for the estates just out of an abundance of caution to ensure that, hey, we didn't miss anybody, or there's somebody out there, a sister or brother that didn't get involved or something like that. So that's just why we do that. Usually if it's a large, we usually like, hey, let's get this thing down because it's a big business risk, and we don't want to, especially when you're drilling 8 wells, that business risk goes by 8 at that point, and we wouldn't do it at that point.
Understood. Thank you.
Good
I don't
question.
have any other questions for the witnesses. Before we move on, are there questions from anyone else, division or petitioner? Okay, good. Mr. Haynes, can you provide a final statement on behalf of the division?
Sure.
As it relates to the request for agency action?
Thank you. Yeah, division, we have reviewed the request that was submitted. And we reviewed the exhibits. We've also reviewed the declarations by Mr. Adamson and Mr. Gravy. Based on the presentation here as well, the division has no opposition to the request for agency action here today.
Thank you. And Mr. Mayo.
With that, I think it's probably appropriate for me to move for admissions of exhibits A through M, inclusive of the declarations obviously filed last week on the 15th. And I'd just like to briefly say the statutory and regulatory requirements have been met, and the relief requested is reasonable, fair, and justified based on the record. And I'd like to thank the hearing examiner and the division staff for the time and attention setting this up today. With that, I'll rest.
Thank you. Mr. Haynes, any objection to the admission of the exhibits?
No objection.
Okay, the record will reflect that those are admitted. I have reviewed the request for agency action. I've reviewed all exhibits submitted, and I've also considered the evidence presented here today. I find that XCL has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose a requested non-consent penalty. I also find that XCL has met its burden of proof to show that they are entitled to forced pooling of the named interests and other relief requested in the request for agency action. Mr. Mayo, will you prepare a proposed order?
I'm happy to. Yeah, I'll try and get it to the division hearing examiner end of this week.
Thank you. And I will then present that to the Board of Oil, Gas, and Mining next week.
Perfect.
Any other comments before we close this proceeding? All right, if there are no other comments or issues, thank you for your participation. We will adjourn this proceeding. Let me get my bearings here. The next one. Does anyone need a break before we move on?
I'm good.
Okay. Great. So again, good morning, everyone. Welcome. My name is Gary White. I'm an Assistant Attorney General, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, February 21st, 2024. The time is 9:25 a.m. This is the time and place for the hearing examiner proceeding for docket number 2024-009, cause number 132-28, in the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton formations comprised of sections 29 and 30, Township 2 South, Range 3 West, USM, Deschênes County, Utah. We are holding this hearing today with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before we begin this proceeding, are there any members of the public or respondents present, either in person or online, that wish to comment in these proceedings? Okay, let the record reflect that there is no public or respondent present who would like to comment. I'll take appearances of counsel this time.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear PLLC on behalf of petitioners XCL Resources and XCL Asset Co.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. And the same housekeeping items as our last proceeding, I've received declarations from Mr. Kevin Anenson and Mr. Mark Gravy in this matter, and I've reviewed them prior to the hearing. Does the division have any objections to these declarations or the declarants being qualified as expert witnesses today?
No objection by the division.
Great. They are so recognized as experts in their particular field of expertise for the matter. And Mr. Mayor, are those witnesses present today?
They are both present electronically. Pursuant to board order entered on February 20th in this cause.
Thank you. Let's have them sworn in, please.
Please raise your right hand. Hands, please. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Mayo, go ahead.
Thank you for that. As I said, Mitch Mayo of Lear & Lear PLLC on behalf of the petitioners in this cause, XCL Resources and XCL Asset Co. With me today, as mentioned, are Mr. Kevin Anson, Vice President of Business Development and Land for XCL, and Mr. Mark Gravy, Executive Vice President of Reservoir. Mark, if you could identify yourself with a wave. Thank you. Pursuant to the board's order on January 17th in this cause, this matter was referred to this hearing examiner proceeding today on the presumption that the matter remained uncontested. I'd like to clarify on the record, this matter is still uncontested and appropriate here today. As mentioned also, the petitioners witnesses, Mr. Anson and Mr. Gravy, submitted declarations of their full testimony to be considered here today, and we won't belabor that, but we will hit on key points and make them available to answer any questions that the parties have. The board, and by designation, the hearing examiner has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5 and the implementing regulations. A copy of the request in this matter was sent by certified mail to the known parties sought to be compulsory pooled and sent by regular mail to all other production owners within the drilling unit. at their last address disclosed by the relevant realty records and by XCL's internal records, including to all federal, tribal, state agencies applicable in this, including to the DFFSL, Division of Forestry, Fire, and State Lands, due to ownership within the drilling unit. In addition, notice of the filing of the REA and this hearing were published in the Uinta Basin Standard on January 31st, the Deseret News on February 2nd, and the Salt Lake Tribune on February 4th. On February 7th, in this cause, the division filed a notice of non-opposition pending the presentation of evidence here today. No other objections or responses to the REA were timely filed. In brief summary, this cause before you involves a request to compulsory pool a drilling unit established in cause number 139-135 for Lower Green River Wasatch Colton production, comprised of the entirety of sections 29 and 30, Township 2 South, Range 3 West. In accordance with the 139-153 order, as modified subsequently by the board's order in cause 130-21, XCL drilled the 8 Jenny wells at issue, each of which is now producing. There are currently no named parties to be pooled here today and declared as non-consenting parties in the 8 Jenny wells. In the request for agency action on file, there were 2 named parties, Ms. Michelle Marie Ludlow and Paul Wallace Weiniger, both of whom have reached out and leased to XCL during the pendency of this action. Regardless, it's still important to go through this because there are several named estates to be pooled here today, and that is what will be the focus of this hearing. As addressed in paragraphs 16 and 17 of Mr. Anderson's declaration in Exhibit M, several estates are named to be pooled. As discussed, XCL believes it has leased all successors or heirs to those estates, but without conclusive court order, is including them to be pooled out of an abundance of caution. As you'll see in Exhibit K on file, an affidavit of publication identifying the, no, Exhibit H. Oh, sorry, I'm lost. Yes. Exhibit K on file is an affidavit showing the publication to those estates pursuant to the board's order entered on January 17th. As reflected in Exhibit H, and as discussed in Mr. Anderson's declaration, paragraphs 30 and 31, the average weighted fee landowner's royalty as of the date of the spud of the first of the Jenny wells is 15.85674.6%. And with that, I'll move into examining the witnesses briefly. I'll examine both witnesses and then open both witnesses up for questioning. Mr. Anderson, can you please state your name and your position with XCL for the board and your business address?
Yes, Kevin Annenson, XCL Resources Vice President of Business Development and Land. Our address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And as the VP of Business Development and Land, do you exercise responsibilities over this drilling unit issue?
That's correct.
Okay. I'd like to refer you to what's been filed as Exhibit M, in particular your declaration in that, titled Declaration of Kevin M. Anderson. Are you familiar with that exhibit?
I am, yes.
Okay. And have you reviewed it in its entirety?
Yes, that's correct.
Did you sign that exhibit or authorize your counsel to sign it on your behalf?
Yes,
Okay. And does that declaration, as discussed here today, represent your full and accurate testimony in this cause?
yes, that's correct.
Okay. Any clarifications you'd like to make on the record?
None that I can think of.
Okay. And I'm going to ask you one final question. In your expert opinion, the terms and conditions of the JOA submitted as Exhibit G in this cause, are they fair and reasonable and consistent with what you see in the basin and in the industry more broadly?
Yes, that's correct.
Okay. With that, I have no more questions for Mr. Anderson, but hang tight because you'll have questions coming here in a minute. Mr. Grady, can you please state your name and business address for the record?
Mark Gravy, working at XCL Resources at 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007. Titles EP Reservoir and Development.
Okay. And as the Executive Vice President of Reservoir and Development, are you responsible for this drilling unit at issue? Similar testimony to Mr. Anderson. Are you familiar with what's been filed as Exhibit M in this cause, in particular your declaration, the declaration of Mark Grady?
Yes,
Have you reviewed that in its entirety?
yes,
Okay. Did you sign that declaration or authorize counsel to sign that on your behalf?
yes,
Okay. Um, Does the declaration, as discussed here today, constitute your full and accurate testimony in this cause?
yes, it does.
Okay. And is there anything you'd like to add or clarify to that testimony?
Not at this time.
Okay. A couple questions for you about your expert opinion. In your expert opinion, were the actual costs of the Jenny wells, as reflected in Exhibit J on file, fair, reasonable, and necessarily incurred?
Yes, they were.
Okay. And in your expert opinion, was each Jenny well economic to drill, as that term is used in the 139-153 order?
Yes, it was.
And finally, do the risks discussed in paragraphs 14 and 15 of your declaration contained in Exhibit M justify the imposition of a 300% risk assessment award in your expert opinion?
They do.
Okay. With that, I have no further questions for the witnesses and would open them up to questioning from the division and hearing examiner.
I will open it to the division and its counsel for questions.
Thank you. Mr. Anderson, sorry if this is getting repetitive. Could you please confirm that Michelle Marie Ludlow and Paul Wallace Weniger have been subsequently leased as to sections 29, the subject of sections 29 and 30?
Yes, that is correct. They have been leased.
Okay, thank you. And even though we have no known parties, just on behalf of in the chance there's an unknown in the estate, could you confirm that there were no leases taken in between the spudding of the initial Jenny well and the last Jenny well?
We did take these two leases from Michelle Ludlow and Paul Weingart in between Spud and First Production. These were the only two.
Thank you.
Can I just ask something real quick to
Sure.
clarify? But those leases were taken after all the Jenny wells were spud?
I can get the exact date, but I know at least from First Spud, between First Spud and IP, these wells, from the first well in the batch drilling, that there was a lease taken from that date, from that timeline.
So the question I think they're trying to get
All right.
at, Kevin, was
Yeah.
to the acreage. The acreage royalty is calculated as of the date of spud of a well, but with batch drilling, because it's kind of arbitrary which of the wells starts first, we've taken the position that there's one acreage royalty for these batch of wells. And they're simply trying to clarify whether you think or know, and you may not know, and that's okay. We can supplement the record after the fact if we need to. But they want to know if there were any leases taken from the date the conductor was set for the first Jenny well to the date the conductor was set for the 8th Jenny well. During that, 2-week time frame? They're wondering if there were any leases taken during that time. Is that
Correct.
okay?
Oh, gotcha. That's, as Mark has kind of explained before, it's kind of a smaller timeline. I don't know the exact timeline. I can look that up, but I will say that we did omit from the calculation of the average weighted royalty, these two leases. They equal, I think it's like 0.03 net acres. So obviously wouldn't have a huge sway on the average weighted royalty, but we went ahead and omitted them anyways. Is that answer the question? Sorry.
You're in your affidavit, in paragraph 28, you say they reached out to you by email on February 9th, 2024.
That's correct.
So would that lease have been taken after that date?
Those two leases were
No, that-
definitely taken.
That says
date?
as noted on to,
I'm guessing they were made effective as of the date of first production. if I
Sure,
had to.
sure.
yeah, I can get you the date. Send a quick note to someone on the team while we keep going, and I can have that answer by the time we're done.
Okay.
We can also take administrative notice in the division records and supplement the record to the extent the division feels comfortable with that, or hearing examiner. If you'd like specificity between the wells, like I said, we're happy to do that.
Does that work for the division?
Yeah, if he gets a date and it's, I assume it's after this February 9th, 2024, even if it's made effective beforehand, it's the date the lease was taken. So I don't see this being an issue, but if he can confirm the date.
For the,
At
for the
some point.
Winiger and the
Yeah.
Ludlow leases.
Yeah, and that it's after the spot of the 8th well, right?
Yes.
Right.
It was, she emailed, Kevin, Mr. Anderson and I last 2 weeks ago and said, you know, I received a bunch of stuff and I don't know what to do. And so the lease was pretty obvious. Her brother was one of the unlocatables. Paul is her brother, and had the notice published to him. And she was able to reach out to him, and so he was leased also through the process. So it worked well, but it definitely was subsequent this time.
As always, it's not happening.
Yeah, so, like I said, at some point during this proceeding, I'm sure we'll get some date, but we're at this point, the division's fine, we have no further questions.
Okay, thank you. Mr. Gravy, I don't want you to feel left out, so I have a question for you. Your declaration at paragraph 14 outlines some general risks that are faced with the drilling and completion of these wells. My question is, were there any specific risks? Were there any risks specifically with the Jenny wells that are identified in paragraph 9 of your declaration? So I guess it's 8 wells. Any specific risks for those wells that you haven't already identified in your declaration?
I think it's probably worth noting that of these wells, roughly half of them were the first wells to ever be drilled in that formation in the unit. And that these are the furthest west wells we have ever drilled. So just the general risk of being outside of an area that we are most confident in our description of makes the investments slightly more risky than drilling a well kind of in the center of the rest of our activity.
Okay. Does anyone else have questions? All right, if not, let's have closing remarks from the division about the agency action.
I did get, I sent a note to the landman who works the area and got all the facts or got all the answers. So they've agreed to lease and we still have not received the lease back. It'll be effective prior to the spud, which is what we do on all those. And they've agreed to lease once they receive the forest pool notice.
Did you say it'll be effective prior to the spud or prior to the date of first production?
Prior to spud.
Okay. I guess that's a question for the hearing examiner as to whether that should be included if it's post-dated, effective prior to the spud, or taken prior to the spud. I would assume it's the lease date when it's taken, but
That would be my gut too.
Any follow-up based on that from the division?
Are you concerned if they'll sign?
No, I mean, my note from the landman was that they said they'd agree to do it once they received the forest pool notice. I have no concerns that they wouldn't.
I should make sure they're included.
Oh yeah,
I
of
mean,
course. No, they've received it. They sent us emails. Like Mitch said, he was on one of those emails.
that's one of the toughest parts of this hearing examiner process because it's slightly truncated. Filing the requests, you do end up getting people almost every hearing who come out and say, you know, now I got this, or now I know it's serious, I need to do something. So there are changes that happen during the process, but you know, I think essentially XCL has taken the business risk that it's better to take them out, knowing they probably won't be appropriate to be pooled, bear the risk that they won't sign, than it is to include them, knowing they're probably leases in the mail.
All right. With that, let's hear closing remarks from the division about the request.
All right. Thank you. So the division reviewed XCL's request. We reviewed their exhibits, and we've also reviewed the declarations of Mr. Anderson and Mr. Gravy. Based on the presentation here today and the discussion by these witnesses, the division has no opposition to this request.
Thank you. And Mr. Mayo, closing remarks.
I'm going to keep them very brief. But we believe the record reflects that all regulatory and statutory requirements have been met for granting this RAA. The relief requested is reasonable, fair, and justified. Before we close, though, it's probably appropriate to move for admission of exhibits A through N in this cause, including the declarations, obviously, exhibit N.
Any objections?
No objection.
All right, they are so admitted.
Okay. And with that, I'd just like to thank the hearing examiner and the division staff and for their time and attention to this matter. And I rest.
Thank you. Having reviewed the request for agency action, the exhibits, and having considered the evidence presented here today, I find that XCL has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. And that's, of course, with the exception of the two named parties who have become consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that XCL has met its burden of proof to show that they are entitled to force pooling of the named interests and other relief requested in the request for agency action. Mr. Mayo, will you please prepare the proposed order?
I'm happy to, and I'll try to get that, like I said, to division and hearing examiner by the end of the week for review.
Thank you. Any other comments before we close? If there are no other comments, thank you for your participation. We will adjourn this proceeding. Does anyone need a break before we move on to the next one?
I'm good.
Okay. Let me just get my bearings here. Morning again. Welcome. My name is Gary White. I'm an Assistant Attorney General, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, February 21st, 2024. The time is 9:47 a.m. This is the time and place for the hearing examiner proceeding for docket number 2024-010, cause number 132-29. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton formations, comprised of sections 29-32, Township 2 South, Range 3 West, USN, Deshane County, Utah. We are holding this hearing today with an anchor position in the Department of Natural Resources, the Natural Resource Building in Salt Lake City, Utah. Before we begin, are there any members of the public or respondents present that wish to comment in these proceedings? And that would include online. Hearing none, let the record show that there is no public or respondent present to comment. I'll take appearances of counsel at this time.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear, on behalf of the petitioners in this cause, XCL Resources, XCL Asset Co.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Excellent. The same housekeeping as before. I've received declarations from Mr. Kevin Annenson and Mr. Mark Gravy in this matter and have reviewed those prior to the hearing. Does the division have objections to these declarations or the declarants being qualified as expert witnesses?
No objections by the division.
They are so recognized as experts in their particular field of expertise for this matter. And Mr. Mayo, are those witnesses, do they continue to be present?
They appear to be. Will you guys raise your hands so we know you're alive? Thank you.
Very good. They can hear us. Let's have them sworn in, please.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Mayo, proceed.
Thank you. I appreciate the introduction on the housekeeping. It helps keep things on track, so I'll try and be succinct. As I said, Mitch Mayo of Lear and Lear, on behalf of the petitioners in this cause. And with me today are Mr. Kevin Anderson and Mr. Mark Gravy. Kevin Anderson is the Vice President of Business Development and Land for XCL Resources, and Mark Gravy is the Executive Vice President of Reservoir Development for XCL. Pursuant to board's order entered on January 17th, this matter was referred to this hearing examiner proceeding, but on the presumption that this matter remained uncontested. I'd like to confirm on the record here that this matter is still uncontested and it's appropriate to be decided at this hearing today. As mentioned, petitioners witnesses, filed sworn written declarations in advance of this hearing that detail their full testimony, but each of them are available here to answer questions and corroborate that testimony as need be. The board, and by designation, the hearing examiner has jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5 and the implementing regulations. A copy of the request was sent by certified mail to the known parties sought to be compulsory pooled and sent by regular mail to all other production interest owners within the drilling unit at their last address disclosed by the relevant realty records and XCL's internal records. A copy of the REA was also mailed to all relevant federal, tribal, and state agencies, including the DFFSL, Division of Forestry, Fire, and State Lands, due to mineral ownership within the drilling unit at issue. In addition, notice of the filing of the REA and the hearing here today was also duly published in the Uinta Basin Standard on January 31st, Deseret News on February 2nd, and the Salt Lake Tribune on February 4th. On February 7th, the division filed a response expressing no opposition to granting the REA pending the presentation of evidence here today and the declarations submitted last week. No other objections or responses to the REA were timely filed. Now, by way of brief summary, this cause involves a request to compulsory pool a 2,560 acre drilling unit established in cause number 600-04 for Lower Green River Wasatch Colton production, which drilling unit is comprised of the entirety of sections 29, 30, 31, and 32 of Township 2 South, Range 3 West in Duchesne County. In accordance with the 600-04 order, as modified by the board's order in cause 130-21, XCL drilled the Jenny 79 and the Maximus 50, the wells at issue, each of which is now producing. There are 3 named parties to be pooled and declared as non-consenting parties in the 2 wells at issue: Urban Fund DU-1 LP, Urban Fund IV LP, and Mark Massey. As reflected in Exhibit N, declarations, testimonial, the aggregate gross working interest of these parties is approximately 1/6 of 1%, 0.1703%. Michelle Marie Weiniger and Paul Wallace Weiniger were each named in the RAA to be pooled. However, as of February 9th, they reached out and the parties have agreed to lease. Accordingly, they are removed from the request and the order here today. As outlined in Exhibits I and J on file and paragraphs 18 and 19 of the declaration of Kevin Anderson, the requisite notices of opportunity to participate in the 2 wells at issue were provided to all these parties, but none timely responded. Mr. Anderson will clarify in his testimony that notice was sent to ConocoPhillips as the predecessor to Urban Fund entities, and we'll discuss the leasing of the Weinigers as well during his testimony. In addition, as addressed in paragraphs 16 and 17 of Mr. Anderson's declaration, there are several estates that are named to be pooled. XCL believes it has leased and voluntarily pooled all successors of these estates, but without a conclusive court order is required to pool them here today out of an abundance of caution. It should be noted that XCL provided anyone claiming buy-through under these estates with notice of this hearing and the request for agency action and their opportunity to participate in the wells by publication, as authorized by this board's order on January 17th. And that's memorialized with Exhibit N on file. Finally, as reflected on Exhibit H and discussed in paragraphs 30 and 31 of Mr. Hannonson's declaration, the average weighted fee landowner's royalty as of the date of spud of the first of these two wells is 17.178870. With that, I'll begin with my testimony of Mr. Annenson. Mr. Annenson, could you please state your full name and your business address for the record?
Kevin Annenson, XCL Resources, Vice President of Business Development and Land, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. As Vice President of Business Development and Land, is it fair to say you have responsibilities over the drilling unit at issue?
Yes, that's correct.
Okay. I'd like to have you confirm your declaration testimony, if you could. What's been filed as Exhibit N, as in Nancy, in this cause, do you recognize that exhibit? Are you familiar with, in particular, the portion titled Declaration of Kevin M. Annenson?
That is correct, yes.
Okay. And are you familiar with all the allegations in that declaration?
Yes,
Did you sign that declaration or authorize counsel to sign it on your behalf?
yes, that's correct.
Okay. And does let me ask a couple questions before we move on to the rest of the declaration. I mentioned in my introduction, we were going to clarify a couple things on the record. First of all, there were 5 parties named in the request. There are now 3 to be pooled. Can you please quickly tell the Division and Hearing Examiner why Paul Wallace Weiniger and Michelle Marie Ludlow are being removed from the request in this hearing?
Yes, we have received confirmation from both of them that they are going to lease. We have not received those leases yet, but we have a picture of one of the leases from their cell phone. And the other one has confirmed that they signed the lease. They were waiting to get the forced pooling notice before they would sign and send over. And so that's why those 2 have been removed.
Okay, thank you. And one other clarification from my intro. 2 of the parties to be named are Urban Fund D-1 LP and Urban Fund IV LP. These Urban Fund entities, they didn't receive notices of opportunity to participate. Can you explain for the Division and Hearing Examiner why that is and that their interest was sufficiently noticed?
Yes, we, at the time of the elections, the record title owner was owned by ConocoPhillips. We sent election letters to ConocoPhillips. They sent back to XCL Resources that they would non-consent these wells. So we received non-consents from Conoco. And then subsequently, after receiving notice from Conoco that they would non-consent, and beyond 30 days, they assigned this interest to both this urban fund, these 2 urban fund companies. And because of both of those events, they do not get the opportunity to participate in any of these wells.
Perfect. Okay, one last question about your deck. Does your declaration Exhibit N as conform to your testimony here today? Does it represent your full and accurate testimony in this cause?
Yes, that is correct.
Anything else you'd like to add or modify before we move on?
Nope.
Okay. In your expert opinion, Mr. Annenson, are the terms and conditions of the JOA submitted as Exhibit G fair, reasonable, and consistent with what you see commonly in the basin and the broader industry?
Yes, that is correct.
And with that, I'll move on to Mr. Gravy if you're available and ready, Mr. Gravy.
I'm ready.
Okay. Can you please state your full name and business address for the record?
Mark Gravy, at XCL Resources, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and your work title and responsibilities as they relate to this matter.
I'm the Executive Vice President of Reservoir and Development.
Okay, and in such a role, I'm assuming you have, is it fair to say you have some oversight responsibilities of the drilling unit at issue?
That is correct.
Okay. 1 second. I'm going to do the same thing I did with Mr. Anderson. I'm just going to walk through your declaration and make sure you're comfortable with what's been submitted as your testimony. Do you recognize what's been filed as Exhibit N in this cause, as in Nancy, specifically the pages relating to your declaration, the declaration of Mark Gravy?
I do.
And have you read and are you familiar with all the allegations in the declaration?
Yes, I am.
Did you sign this declaration or authorize counsel to sign it on your behalf?
Yes, I did.
And does the declaration as presented here today constitute your full and accurate testimony in this cause?
It does.
Okay. Is there anything you'd like to clarify or modify before we move on to a few final questions?
Not at this time.
Couple of questions about expert opinion, if you could. In your expert opinion, would you say the actual costs for both the Jenny 79 and the Maximus 50 wells, the wells at issue in this cause, as reflected in Exhibit K, are fair, reasonable, and necessarily incurred?
Yes, I do.
And would you say that each of the wells at issue was economic, as that term is used in the 604 order when they were drilled?
Yes.
Last question. Is it your expert opinion that the risks discussed in your declaration, specifically paragraphs 13 and 14, that they justify imposition of a 300% risk compensation award in this cause?
Yes, I believe they do.
Okay. With that, I have no further questions for the witnesses and would open it up to division hearing examiner.
We'll now have the division and its counsel ask questions.
Thank you. Thank you for those clarifications. That helps answer a lot of the questions we have. Again, though, we do have a question. Do either of you, Mr. Gravy or Mr. Anson, have the spud dates for the Maximus or the Jenny in this situation?
I believe you sent those out, correct, Kevin?
Yeah, you got them in front of you, Mark. I'll pull them up.
I am pulling them up quickly.
Give me 1 second. I'll go to you. It is the Maximus 50-3231-23D, was July 19th of 2022. And then the Jenny 79-29-30-23H was September 19th, 2022.
And Kevin, oh, sorry.
Okay, good.
Mr. Anderson, do you know, there's a lot of different potential spud dates. Do you know, are you talking setting surface casing? Are you talking sputter rig? Do you have any sense of which of those dates that reflects?
See, based off the dates of the other ones, Mark, I'm assuming that was conductor, correct?
That looks like conductor to me,
Yes.
because from our record, some wells share the same spud date, so it wouldn't be possible to set surface casing on more than one well in the same day, but conductors is possible.
That makes sense. Thank you.
And so, to the best of your knowledge, we have again an average weighted royalty calculation. Is that average royalty that we've been provided here, the royalty that would have been in place at the time of the spudding of both of these wells?
That is correct.
Okay, we have no further questions.
Mr. Anderson, just a point of clarification, paragraph 14 of your declaration references Urban Fund, those two entities. Have you ever had communication with Urban Fund about these wells?
We sent them the RAA, but never heard anything back.
All right. And I guess my follow-up would be at footnote 3, last line and a half or so. It would be your understanding that these urban entities took their interest after Conoco became non-consent.
Yes, that is correct. We received the non-consent from Conoco, and then it was after the 30 days, and then the assignment happened.
Okay. Thank you.
Did that answer it?
Yeah, that helps me. Thank you.
Yep, of course.
Is it questions for the witnesses? All right, Mr. Haynes, if you could tell us the here.
All right, thank you. The division has reviewed the request by FCL that they submitted, reviewed the associated exhibits that have been provided. Also reviewed the declarations provided by Mr. Gravy and Mr. Adamson. So based on the presentation here today and the questions that were asked, the division has no opposition to this request.
Thank you. And Mr. Mayo, if you could conclude.
Happy to, thank you. Just really briefly, our position is that the record reflects pretty clearly that the statutory and regulatory requirements have been satisfied in this cause, and that the requested relief as outlined in the REA and confirmed here today in the testimony is fair, reasonable, and justified. And we just ask that this REA be approved. It's probably appropriate before I move on to move for admission of petitioners exhibits A through N as in Nancy in this cause. That will include the declarations of Mr. Hennons and Mr. Gravy filed as exhibit N last week.
Any objection?
No objection.
So admitted. Mr. Mayo, anything further?
Nothing further with that. I'd just like to thank Division and Karen Examiner for their time and attention in this matter.
Thank you. I've now had an opportunity to review the request for agency action, as well as the exhibits, the declarations, and as well as the evidence presented here today. I find that XCL has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. And the exceptions there are the two who have indicated they will lease. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that XCL has met its burden of proof to show that they are entitled to forced pooling of the named interests and other relief requested in the request for agency action. And Mr. Mayo, will you please prepare a proposed order?
I'm happy to. Yeah, thank you.
Thank you. Any other comments before we adjourn?
And it'd probably be appropriate. Is it okay when we adjourn just to holler at them and tell them they're free to go?
Absolutely. As soon as we adjourn, gentlemen, you're free to go. Thank you. If there are no other comments or issues, thank you for your participation. We will adjourn this proceeding.
Thank you.
Thank you.
And we're gonna switch chairs here.
Thank you, guys. Quick question, while everyone's in there, it sounds like we should bring some spud dates. I think that was a lot of questions, perhaps to the next force pooling. That may be helpful, right, Mitch?
I'm gonna talk offline with these guys and see if we can get a consensus on what the unstated law in Utah really is.
Yeah, that'd be great. Yeah, just to help out, to cause any confusion, and I hope I can't remember who I answered the question earlier, but ask if we were worried about the non-consent. I hope I was able to clarify it as I got it, that we have a picture of one and the other one said they signed it and sent it. We're just waiting on it. So hopefully that
That's
some
no
clarity.
problem.
You're pretty
Thanks,
good.
Dan.
Okay, thanks, guys. Have a great day.
Usually when I read, people will holler at me.
Yeah, no, you're fine. You're great.
Okay.
Yeah.
Rich, does it feel better in here? Hopefully.
I was
Okay.
crazy that first
Yeah,
year.
it was warm in here.
Okay, that wasn't just me.
I was like, as soon as I got in the room, I'm like.
I was like, I must be more nervous.
Yeah, I was gonna say, you sweat. You and me. We've got first of feathers.
I'm not used to my.
Wow, yeah. It's when Dustin showed up. When you guys showed up, it made Mitch nervous.
I know, right? That I'm a geologist, engineer combo over here. Matt, can you check and make sure Ash, Chris, maybe with this volume?
Absolutely. Hey, let's see, Christopher Wall and Ashley Ellison, if we can have you, bring your cameras online and give us a sound check, that would be great. Christopher, go ahead first.
Sound check.
Yeah, just make sure you talk up so that we can hear you, but yeah, we can hear you.
Yeah, I can-
Okay, Ashley?
Yep, I'm here. Can you hear me?
Contact is good, thank you. Just both of you, make sure you talk up so we can hear you. Okay, thank you, gentlemen.
Thanks.
You're welcome. And Fred, do we have, two matters to be?
No, I'm doing one and then Ginger will do the other. But they're both really good.
Okay.
Chris will be both on both. And then another one, and then keep doing just-
Okay, that's right. Awesome, thank you. This camera loves me. It will stay on me the whole meeting. I think it's, I'm sure.
You just look good on TV.
I
That's all.
guess.
You need an agent?
I'll take an agent. How can I help you? Do you need power?
I think I have power now.
Okay, because I think there's, I don't know if this one's close enough, but there's a power strip here. If we can get you over here.
I did it, you guys.
Oh,
Christina.
Christina, I know. That's okay. We had so many Michelles in a row. It's crazy. Okay, so we're all good on power? Okay, fantastic. Awesome. Thanks, Christina. That's great.
Just at the, otherwise, ask the question, spelling. I don't know if you.
Okay. I have paper copies of the files. I have to-
Great job.
Oh, thank you.
Nailed it.
I hope so. Yeah, that was perfect.
It goes to show that a broken clock is right. No, not 3 times a day, only twice.
Only twice.
I must have known what I was doing by the end. I want everyone to know I spent all day yesterday reading those stories, trying to figure it all. Oh, yeah. Wow, you knew him well. That was great.
Crash course in 101 on compulsory pooling. Huh?
Yeah, the good news is I get it now, so.
Yeah.
Perfect.
Wait until it's contested.
Yeah.
It's a little more exciting.
I'll be
The advent of video conferencing has probably made this far more economical, I imagine.
Oh, yeah. The witnesses absolutely love not having to fly up here for a day.
Yeah. I'll bet.
Unfortunately, we don't have anybody else that's just here in Salt Lake.
Yeah,
So
that's a good point.
hey, John, how you doing?
You're looking at Tanner.
Oh,
I see
no acknowledgement.
Oh, I just covered myself up. That's good. We've been in Salt Lake a couple months. It's not- always- Lucky guy. Already. Yeah, I think there's like 5.
You know what's for
Who's messaging me over here? Little Regina, I go over here. She doesn't write me messages.
Yeah, what you have to say. Maybe I should reach out.
She's wondering why the dress code's different. Is it fry? I don't know,
I just come as, STEM casual.
which I appreciate. I should put a collar on. See, Dustin, I got the men on short sleeve. He's got a collar? Yeah, it's just. No, you look good. I'm just saying, like, this is. Try church. Hold the stand. Yeah, let's keep standing.
Just so you know, they online, they had the wells were still drilling.
I thought it was just engineers as well, so thank you for confirming.
See how close they are in the new. I don't need it. If they can watch your exhibits, I'm not.
Oh, really?
Do you have all your online? Is
Yes,
everyone
everybody's
good?
on.
Settled?
Yeah,
Okay.
we're ready to go.
And Andrew, you?
Yeah, we're good.
Okay. All right.
Yeah.
Okay,
Gotta give you the countdown.
let's,
We're-
Give me the countdown.
are you
we're good.
good, Matt? Thank
Yep.
you.
Yep, we are ready to go.
Awesome. Good, not quite afternoon yet, but almost. Good morning. My name is Madeline Whittier. I'm an Assistant Attorney General, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this matter. Today is Wednesday, February 21st, 2024. It is 10:23 a.m., and we are located here at the Department of Natural Resources Building in Salt Lake City, Utah. This hearing examiner proceeding is for docket number 2024-011, cause number 132-30, in the matter of the request for agency action of Ovintiv USA Inc. for an order partially vacating the order entered in cause number 139-104 and instead pooling interests, including the compulsory pooling of the interest of certain non-consenting owners in the Jurgensen 13-7, 3-1-7-6-5H, 13-7, 3-1-7-6-16H, and 13-7, 3-1-7-6-46H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, comprised of all of sections 6 and 7, Township 3 South, Range 1 West, Duchesne County, Utah. Before we begin, are there any members of the public in person here today or online who would like to comment on this matter before we get going? Seeing none, I'll go ahead and take appearance of counsel.
Fred McDonald of Council with Clear and Mayor on behalf of petitioner Ovintiv USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you very much. I would also like to state for the record that in this matter, I've received and reviewed testimony by declaration from one Mr. Ashley Ellison and one Mr. Christopher Wall. Division, do you have any objection to the declarations submitted or these witnesses being recognized as experts?
No objection by the division.
Excellent. They are so recognized then. And could we please swear in those individuals planning to make testimony today? Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Yes.
Thank you. And with that, Mr. McDonald, would you like to start us off?
Yes, thank you, Madam Hearing Examiner. First of all, to clarify for the record, Mr. Ellison is being recognized as an expert in petroleum land management. And Mr. Wall is being recognized as an expert in petroleum engineering and in specific reservoir engineering for purposes of this cause. As was stated pursuant to the board's order entered on January 17th, 2024, this cause was referred to a hearing examiner, presuming the matter remained uncontested, which I will address shortly as the case. I want to confirm that both the hearing examiner division received revised Exhibit G, which was filed last week, and also Exhibits N and the supplement to Exhibit Z that were filed yesterday.
Yes.
Yes, we have.
Thank you. All right.
The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations found in R 649-28A and R 649-2-9A. A copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and OBIN's internal records, and also to the Bureau of Land Management due to the federal mineral ownership within the drilling unit. In addition, notice of the filing of the request for agency action in this hearing was also duly published in the Uinta Basin Standard on January 31st, 2024, the Deseret News on February 2nd, 2024, and the Salt Lake Tribune on February 4th, 2024. On February 7th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request for agency action, and no other objections or responses were timely filed to the request. I'm going to briefly summarize the case and the testimony of our witnesses that were shown in the declaration just for the record. The cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch production comprised of the entirety of sections 6 and 7 of Township 3 South, Range 1 West in Duchesne County. That drilling unit was established by the board's order entered in cause number 139-134. Ovintiv is the majority working interest owner as reflected in revised G and in paragraph 13 of Mr. Ellison's declaration. A true and correct copy of the 139-134 order was submitted as part of Exhibit B in this cause. The 139-134 order modified the previous board's order entered in number 139-90, which established section 6 and 7 respectively as sectional drilling units for the Lower Green River Wasatch production. Pursuant to the 139-90 order, Newfield, Ovintiv's predecessor by merger and name change, drilled 4 wells, 2 each in each of the sectional drilling units. They are identified in paragraph 9 of Mr. Ellison's declaration and shown on Exhibit F submitted in this cause. Pursuant to the board's order entered in cause number 139-104, certain parties were compulsory pooled and declared as non-consenting parties in the 2 wells drilled on the section 7 drilling unit under the 139-90 order, all as outlined in paragraph 10 of Mr. Ellison's declaration. Neither of those wells has paid out. A true and correct copy of the 139-104 order was submitted as the remainder of Exhibit B in this cause. As for the 2 wells in section 6, Newfield elected to carry certain parties rather than seek compulsory pooling due to the small amount of interest involved. All is outlined in paragraph 11 of Mr. Ellison's declaration. Neither of those wells have paid out either. Nevertheless, the 139-134 order expressly provides that the 139-104 order is to be vacated, and Ovintiv, as Newfield's successor, agreed to waive any further recoupment from any of the non-consenting owners in those 4 existing wells, effective as of the first of the month following the date of first production of the first long lateral horizontal well drilled upon the section 6 and 7 drilling unit established under the 139-134 order. Furthermore, production allocation from those existing wells converts to the section 6 and 7 drilling unit basis as of that date as well. This is all outlined in paragraph 12 of Mr. Ellison's declaration. In accordance with the 139-134 order as modified by the board's order entered in cause number 13016, which reduced the heel toe setbacks, Ovintiv drilled the 3 Jurgensen long lateral horizontal wells at issue in this cause, with first production from all 3 on October 5th, 2023, outlined in paragraphs 7 and 8 of Mr. Ellison's declaration. The conversion of the production allocation from the existing wells therefore occurred on November 1st, 2023. There are 4 specific parties to be compulsory pooled and declared as non-consenting parties in the 3 Jurgensen long lateral wells. Bonnie Mae Brown, Melvin Keith Larson, Michael David Jurgensen, and Mark Torgerson. As reflected in revised Exhibit G, the aggregate gross working interest of these parties in the drilling unit at issue is 0.831%. As outlined on Exhibits H through O in paragraphs 15 through 22 of Mr. Ellison's declaration, the requisite notices of opportunity to participate in the 3 Jurgensen wells was provided to these parties, including by publication to Ms. Brown as authorized by the board's order entered on January 17, 2024, but none of those parties have timely responded. In addition, although Ovena believes it has leased all successors and voluntarily pooled their interest pursuant to the pooling clauses contained in those leases, there may be additional parties claiming by, through, or under certain decedents as identified in paragraph 20 of Mr. Ellison's declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interest. Pursuant to the board's order entered on January 7, 2024, the requisite notices of opportunity to participate in the 3 Jurgensen wells was provided to them by publication. No response to the publication were received. Exhibit N admitted in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit P and in paragraph 25 of Mr. Ellison's declaration, the average weighted fee landowner's royalty as of the date of spud of the first Jurgensen long lateral horizontal well is 15.517298%. Pursuant to statute that does not include the royalty under the federal lease that's involved in this drilling unit. As outlined in paragraph 26 of Mr. Ellison's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the section 6 and 7 drilling unit. Their names and addresses were derived from a 2022 title opinion as supplemented by a record search by Ovena's contract landmen and based on Ovena's internal records. Exhibit Z as supplemented reflects the status of the certified mailings of the request for agency action to the 4 expressly named compulsory parties, as it will reflect several of them that refused to pick up the packages after being delivered to their addresses. Attempted delivery to their addresses. As the record will reflect, none of these parties as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovena moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion.
Default is granted. Please continue.
Any
As long as
objection to
the
that from the
division does
division?
not have an objection. Thank you.
Thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for each of the Jurgensen long lateral horizontals is $75,000. Exhibits R and S in paragraphs 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of spud of the 3 Jurgensen wells. With that, I'll commence a brief examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
And what is your current position with Ovena?
Yes, I'm a senior landman.
And do you have responsibility over this drilling unit at it?
Yes, sir.
And would you please state for the record the bonding status of Oventive?
We're a company in good standing. I'll pull up the info. Yeah, we're bonded with the state. Sorry, I am not tracking this well here.
All right, just to remind you from your declaration, I believe you stated that Oventive is a Delaware corporation with its principal business in the Woodlands, Texas. Is that correct?
Sorry, yes, that is correct, sir.
All right, and is it also the successor by name change to Newfield Production Company and Oventive Production, Inc.?
Yes, sir, that is correct.
All right, would you confirm for the record that exhibits C through M, O, and P were prepared by you, Oventive personnel or contractors with your review and input?
Yes, sir, that is correct.
All right, have you had an opportunity to read and confirm, read your declaration?
Yes, sir.
Can you confirm for the record that all the statements made in the declaration are true and correct?
That is correct, sir.
And have you authorized me to sign that on your behalf?
I have, sir.
And finally, do you confirm for the record that that constitutes your full and accurate testimony if asked all those questions?
Yes, sir.
Okay, finally, is it your expert opinion that the terms and conditions of joint operating agreements submitted at home are fair and reasonable, consistent with those commonly accepted by the industry, and in particular, the Uinta Basin with respect to horizontal well operations?
I do, yes.
With that, I would open, Madam Hearing Examiner, for questions from the division and yourself.
Thank you. Division, we'll go to you first if you have any.
Mr. Ellison, I think you are the correct person to ask this. We'd just like to know, did you prepare the average weighted owner royalty?
I worked with the lease analysts that prepared it, so we worked on it together.
Okay, great. So in this situation where we have 3 wells in this unit, so we'd just like to clarify that royalty would apply to all 3 wells. And so are you aware of the spud date of the 3 wells?
Yes, sir. The conductor spud date was March 20th of 2023.
Was that for all 3?
They kind of do it all consecutively, so I think it's the dates are a couple days. Yeah.
And so the average weighted royalty that's being requested, that is the royalty rate that should apply to all 3 wells. So there was no leases taken to indicate the spudding of the first well and the spudding of the 3rd well.
Sure. Yes, it's all. They'll be applied to all 3 wells, and there were no leases taken within like the 4 or 5 day time frame between the conductor set of one of the wells and the other wells, or the other 2 wells, I suppose.
Okay, thank you.
Yes, sir.
I was just gonna maybe clarify, I think in the declaration, it says the spud of 2 of the wells are on March 27th, 2023, and the 3rd well, the 5H, was spud on April 6th of 2022.
Right,
So I
it's
think
in-
those are the dates.
Yeah. For the record, that's in paragraph 8 of Mr. Ellison's declaration.
That is correct.
That's all I have.
Thank you. I have no questions. Mr. McConnell, we can turn to your next witness.
Thank you. I'll commence my examination, Mr. Wall. Mr. Wall, would you please state your address for the record?
Yes, my name is Christopher Wall. I work for Oventive USA Inc. As a senior reservoir engineer with an address of 4 Waterway Square Place, Suite 1000, The Woodlands, Texas 77380.
What is your current position with Oventive?
Senior reservoir engineer on the Utah asset.
And that would include working this unit at issue today, is that correct?
Correct.
Thank you. Would you please confirm for the record that exhibits Q through S were prepared by you or Oventive personnel to review and input?
That is correct.
All right, would you confirm that you've read your declaration?
That is correct, yes.
Authorize me to sign that on your behalf?
Yes,
Also confirm for the record that all the statements made in your declaration are correct? And
yes,
constitute your full and accurate testimony that you would give today if asked these questions.
yes.
All right, finally, in your expert opinion then, are the actual costs of the 3 Jurgensen long lateral wells at issue with exhibit Q fair, reasonable, and necessarily incurred?
Yes,
Is it also your expert opinion that each Jurgensen well was economically feasible to drill in the 139, 134 order?
yes,
Finally, is it your expert opinion that the risk shown and outlined on exhibits R and S justify the imposition of a 300% risk assessment award and that it's fair and reasonable under the circumstances?
yes.
Madam Hearing Examiner, that concludes the examination of Mr. Wall, and I open it up to questions from the division or yourself.
Thank you very much. Mr. Haynes, do you have any questions for this witness?
The division has no questions for Mr. Wall.
Thank you. Neither do I. So, Mr. McDonald, if I could just confirm for my own notes, at no point has this matter been contested. You received no.
That's correct.
Thank you very much. All right, now we will go ahead and turn to the division. If you have a, please proceed.
Sure, thank you. Yeah, the division reviewed the request by Vintive. We reviewed their exhibits and reviewed their subsequent declarations by Mr. Wall and Mr. Ellison. And based on the presentation here today and the presentation by the witnesses, the division has no opposition to this request and is in favor also of vacating order 139-104 in accordance with order 139-134.
Just for clarification, it'll be a partial vacation
Oh,
because
yes,
139,
as to the
104
subject
deals to other drilling units.
Thank you very much. Yes, just as to the subject line.
Thank you. Anything else from your side, Division? Right. Thank you very much. Back to you, Mr. McDonald, for any closing remarks.
Thank you, Madam Hearing Examiner. Yes, I'd like to move for of exhibits A through F, revised exhibit G, H through S inclusive, and Z is supplemented, as well as Messrs. Ellison and declarations.
Division, do you have any objection to the submission?
No objection by the division.
Okay, so admitted. Well, with that, that was quite speedy all. Thank you. Having reviewed the requests, the exhibits, and the evidence that was submitted and made orally here today, I find it appropriate to approve the request for agency action as submitted and make that recommendation to the board. Mr. McDonald, could you please prepare a proposed order?
Sure.
Thank you. And with that, we will go ahead and wrap up this matter and move on to the next one. Thank you.
Thank you to the hearing examiner, the division, and the IT people for allowing virtual appearance. Ashley, you're okay to cut off there? And then Chris, if you'd stay on, and is Jordan available?
Yes, he should be here. Yep. All right, thanks, guys.
All right, thank you. That was a good sound check, Jordan. Just make sure you speak up. And if I can just remind the remote witnesses to mute your microphones when you are not testifying. It just gives us a little bit of feedback with the little bit of noise that you have there. So if you're not speaking, I just ask that you mute your microphones. Thank you.
Matt, are you good for us?
I'm sorry. Yes,
Keep it
ma'am, I'm good.
rolling? No
Yep.
worries.
We're good to go.
Okay, all right. Good morning. My name is Madeline Whittier. I'm an assistant attorney general, and I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this matter. Today is Wednesday, February 21st, 2024. It is 10:44 a.m., and we are currently located at the Department of Natural Resources building in Salt Lake City, Utah. This hearing examiner proceeding is for docket number 2024-12, cause number 132-31, in the matter of the request for agency action of Ovintiv USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Ute Tribal 13-30, 3-3-31-32-7H well, and the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all of sections 31 and 32, Township 3 South, Range 3 West, Duchesne County, Utah. Before we begin, are there any members of the public that have joined us in person or online who wish to comment on this matter? Okay, seeing none, we will go ahead and take appearance of counsel.
Ginger Utley on behalf of petitioner Ovintiv USA Inc.
Fred McDonald, I'm counsel with Lear and Lear, also associate counsel with Ms. Utley.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Okay, I would also like to state for the record that I have received and reviewed testimony by declaration from Mr. Jordan Lair and Mr. Christopher Wall in this matter. Division, having also received this, do you have any objection to the declarations submitted or these witnesses being recognized as experts?
No objection by the division.
Excellent. They are so recognized then. Could we please swear in those individuals planning to make testimony?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. With that, Ms. Utley, would you like to start us off?
Sure, thank you. As noted, Ginger Utley of Lear and Lear for petitioners, and with me virtually are Jordan Lear and Christopher Wall. They are here pursuant to order designating the hearing examiner dated January 17th, 2020, allowable in uncontested matters such as this. And as I'll discuss, this matter is uncontested. Mr. Lair and Mr. Wall are here and have made themselves available to answer any questions by division or Madam Hearing Examiner. As noted, both submitted declarations identified as Exhibit OO and PP that contain their full testimony. And both have been qualified as experts in numerous prior causes, and presuming no objection from the division, should be identified as experts for purposes of this cause.
Yeah, no objection from the division.
Thanks. The board, and by designation, the hearing examiner, has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations. A copy of the RAA was mailed certified mail to the known parties sought to be compulsory pooled, and mailed regular mail to all other production interest owners within the drilling unit at their last address disclosed by the relevant records of Ovintiv's internal records, and to all relevant federal and tribal agencies. In addition, notice of the filing of the RAA in this hearing was duly published in the Uinta Basin Standard on January 31st, 2024, the Deseret News on February 2nd, 2024, and the Salt Lake Tribune on February 4th, 2024. On February 7th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting the RAA. No other objections or responses to the RAA were timely filed. By way of summary, this cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch formations, comprised of the entirety of sections 31 and 32, Township 3 South, Range 3 West in Duchesne County. The drilling unit was established by board order entered on December 14th, 2021 in cause 130-10. Ovintiv is the majority interest owner as shown on Exhibit E and as stated in paragraph 9 of Mr. Lair's declaration. Pursuant to Order 130-10, which is on file as Exhibit B, Ovintiv spud the subject well on May 27th, 2022, with a date of first production of October 7th, 2022. And I would like to make a correction here. In the request for agency action, the date of first production was mistakenly identified as July 1st. I've informed the division of this error and would like to make an oral modification with respect to the date of first production to clarify that it is indeed October 7th, 2022. And I will, the correct date is referenced in Mr. Lair's declaration in paragraph 7. And because the subject well is the only well that's been drilled and is producing from the subject formations within the drilling unit, conversion is not applicable in this cause, and the change to the date of first production will not affect the allegations or legal conclusions in the RAA in any substantive way. And I will make sure that correction is reflected in the proposed order. There are 26 specific parties to be compulsory pooled and declared as non-consenting parties in the subject well, as identified in the request for RAA and in paragraph 13 of Mr. Lair's declaration. As reflected in Exhibit E, the aggregate gross working interest of these parties in the drilling unit is 0.32%. As outlined in Exhibits F through EE, the requisite notices of opportunity to participate in the subject well were provided to those parties, including by publication to Jim Welch, Daniel G. Smith, and Wesley Clay Smith, as authorized by the board's order entered on January 17th, 2024, but none have responded. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in those leases, there may be additional parties claiming by, through, or under certain decedents, as identified in paragraph 17 of Mr. Lair's declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interests. Pursuant to the board's order entered on January 17th, 2024, the requisite notice of opportunity to participate was provided to them by publication, and no responses were received. Exhibit HH admitted in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate, from the Uinta Basin Standard. As reflected on Exhibit JJ and paragraph 23 of Mr. Lair's declaration, the average weighted fee landowner's royalty to be applied is 19.742587. As also outlined in Mr. Lair's declaration in paragraph 24, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from a 2022 title opinion as supplemented by a record search by Oventive's contract landmen and Oventive's own internal records. Exhibit NN reflects the status of the certified mailings of the request to the expressly named compulsory pooled parties. As the record will reflect, none of the parties identified in the RAA as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Oventive moves to enter an order of default against them.
Do you have any objection to granting a default?
No, I do not. The division has no objection.
Thank you.
Thank you. So granted.
As outlined in paragraph 7 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the subject well is $75,000. Exhibit MM and paragraph 9 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the subject well. And with that, I will begin examining the witnesses. Mr. Lair, will you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your position with Oventive?
I'm the senior land negotiator with responsibilities over this drilling unit, among others.
Thank you. And can you provide the corporate and bonding status of Oventive?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production Incorporated.
Thank you. Were exhibits C through GG, II, and JJ prepared by you or Oventive personnel with your input and review?
Yes, they were.
And with respect to your declaration, which is now on file as Exhibit 00, have you read and can confirm that all the statements contained in that declaration are true and correct?
Yes, they are.
And did you sign or authorize your counsel to sign on your behalf?
Yes, I did.
And is that your full testimony?
Yes, that is.
Do you like to make any additions or corrections to that testimony?
Not at this time.
Okay, thank you. In your expert opinion, are the terms and conditions of the JOA submitted as Exhibit II fair, reasonable, and consistent with those commonly accepted by the industry and particularly in the Uinta Basin Standard?
Yes, they are.
Sorry.
Yes.
Thank you. With that, I'll just move on to the testimony of Mr. Wall and then open it up to questions for both gentlemen. Mr. Wall, will you please state your name and business address for the record?
Yes, Christopher Wall, 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your position with Oventive?
I'm a senior reservoir engineer working the Uinta asset.
Thank you. Were exhibits KK through MM prepared by you or Oventive personnel with your review and input?
Yes.
And with respect to your declaration, which is on file in this matter as Exhibit PP, have you read and can you confirm that all statements in that declaration are true and correct?
Yes.
And does that declaration reflect your full testimony here today?
Yes, it does.
Did you sign or authorize your counsel to sign that declaration on your behalf?
Yes, I did.
And would you like to make any additions or corrections to anything in the declaration?
Not at this time.
Oh, yes. And in your position, are you in charge of this drilling unit? You have supervisory role over this drilling unit?
Yes.
Thank you. In your expert opinion, are the actual costs of the subject well as reflected in Exhibit KK fair, reasonable, and necessarily incurred?
Yes.
Thank you. And can you also, in your expert opinion, do the risks shown and outlined on Exhibit MM justify the imposition of a 300% risk assessment award?
Yes.
Fair and reasonable in this case?
Yes.
Thank you. And with that, I would just open the witnesses up to questions from the division and Madam Hearing Examiner.
Thank you. Division, over to you.
Yeah, thank you. I just want to get a clarification, and this is probably to you, Mr. Lear. The request has a weighted acreage weighted royalty. Exhibit JJ has one, and your affidavit has one. They're both slightly different. I just want to get the exact one. What is the exact royalty we want to use?
It should be the one matching exhibit. Pardon me one second. Exhibit JJ, which is 19.742587%.
Okay. I just want to clarify.
Okay.
Let's get that one.
I'll make that
All right.
clarification.
But other than that, I have no question. The division has no questions. So
Thank you. I think for Mr. Wall, just on the difference in actual costs and the original AFE, could you talk me through what that number was and just explain the rationale for that in your expert opinion being reasonable?
Okay. I don't have the exhibits in front of me, so I don't remember exactly what the cost difference was. However, when I'm assuming you're talking about the estimate for drilling and then the actual costs. Is that correct?
Yes.
Yeah. So we estimate, sometimes we have estimates that are, months out in front of the drilling, and things can change, such as inflation. Can change, especially the cost of tubulars. And so that is primarily driving some of the delta here was the change in prices for not only tubulars, but also services.
Thank you. Okay. And then, are you all set, Ms. Utley, with your witnesses? Okay, thank you. We'll go ahead and turn to the division now if you have a statement.
thank you. Division reviewed Oventive's request, and we looked at the exhibits, and we looked at the affidavits of Mr. Lear and Mr. Wall. Based on the presentation here and their responses, the division has no opposition to this request.
Thank you very much. And Mr. Haynes, I just want to confirm with you that upon review, you're satisfied that the NOPs meet the requirements in R649-1-1?
Yes, based on code 940-6, we're satisfied that the APs that was sent out met the requirement to send out a cost estimate, as well as the fact that no party has contested their notification that were granted. The division has no objection to the notification given here.
Perfect. Thank you very much. I'll turn back to you, Ms. Utley.
Thank you. Just in conclusion, all statutory and regulatory requirements have been satisfied. The requested relief is fair, reasonable, and justified, and we would ask that the request for agency action be approved. I would like to move for admission of exhibits A through PP, inclusive of Mr. Ellison and Mr. Wall's declarations. Sorry, Mr. Lair's declaration. And would just like to thank the hearing examiner and division for their time and attention today.
Thank you. And division, do you have any objection to these exhibits being admitted?
No objection.
Okay, so admitted. On that note, I thank you all for your time. Having reviewed the request, exhibits, and the evidence submitted and made orally here today, I find it would be appropriate to approve the request for agency action as submitted. Ms. Utley, could you please prepare a proposed order? And I just have here, we want to make sure we note the correct weighted royalty.
Absolutely. Yeah,
Thank
I'll get
you.
that to you by the end of the week.
Thank you very much. We will then go ahead and conclude this hearing.
Oh, okay. That's great. Great. Carmen, we're all done.